This diagram shows you the system of legal procedure in settling administrative legal issue. I quote this diagram from the lecture presentation of Mrs. Nurmayani from Lampung University. From this diagram, take a look at the bottom part of the diagram. So the legal case in administrative court is started when there is an individual or a private legal entity, badan hukum perdata, who feel disadvantaged caused by the issuance of the decree of the administrative body or government officer, which has been explained as well at the previous part. So this the individual or the private legal entity disagree with the decree or the decision of the pejabat tun or badan tun, the government body or the government officer. So what the individual or the private legal entity has to do is to search the related regulation about the case they are facing. After reading the related regulation, they could follow several options. In administrative law, we recognize administrative effort. Administrative effort, in Indonesia we call it upaya administrasi. Administrative effort is an effort that has to be followed by an individual or private legal entity who feel disadvantaged caused by the issuance of the KTUN or the government body decree or the government officer decree. So they cannot just directly submit a lawsuit if the related regulation mandates them to follow the administrative effort first. So you cannot directly submit a lawsuit if the related regulations say you have to follow the administrative effort. So you have to follow the administrative effort, and if your administrative effort is failed, then you can go directly to the court. There are two kinds of administrative effort or upaya administrasi. The first one is keberatan or objection. Keberatan or objection is an administrative effort that followed by doing or submitting an objection to the party or the institution or the officer who issued the decree. Back to the case, let's say that I am an employee of a government body or institution, and then the head of the institution, let's say the mayor or the governor or maybe the director, the general director of the institution, issue a decree, and the point of the decree is to dismiss me from my position, is to terminate me or to fire me. So I have to follow the administrative effort first, which is keberatan. So I have to submit a complaint, an objection to the one who issued the decree. In this case, for example, the decree is issued by the mayor, so I submit my letter of objection to the mayor. So I will wait what the mayor said. If the mayor accepts my objection, then the case finished. But what if the mayor rejects my objection? Then the law said there is another administrative effort called administrative appeal or banding administratif. Administrative appeal here is an administrative effort that conducted by submitting an appeal to the institution that higher than the institution or the officer that issued the decree. Let's say that I am a lecturer and then I'm terminated from my position based on the decree of the rector. So I will follow the administrative appeal if I submit an appeal to the institution higher than the rector and the university. In this case is the Directorate of Education, for example, or higher education. So keberatan is submitted to the institution or the officer who issue the decree. Banding administratif or administration appeal is submitted to the higher institution, higher than the institution that issued the decree. So how do I know whether I should follow keberatan or banding administratif? So the existence of keberatan and banding administratif is sometimes optional. Sometimes you have to follow them, but sometimes you don't have to follow them. So how do I know whether I have to follow or not? The law said, the system said that you have to read the related regulation. So if the case is related to the land, let's say that you are disagree with the decision of Badan Pertanahan Nasional because they issued a certificate of a land for someone and you consider that the land is actually yours, so you disagree with the certificate, you want to fight the certificate. So to know what you should do, you have to read the regulation related to that case. In this case, maybe you can read the law of Indonesian agrarian law. So try to find what the law said. If the law say before submitting a lawsuit you have to do keberatan first or objection, so you have to follow keberatan first. So here you can see from the first box to the other box, so individual or Badan Hukum Perdata, that's one box. So you can follow the line there that the individual or Badan Hukum Perdata can do keberatan if the related law mandates you to do keberatan before you submit a lawsuit. So in understanding administrative law, it's not enough only by reading Undang-Undang PT-UN, but you have to read also the other regulation related to your case. Back to my case, let's say I am a civil servant and then I am fired from a position. So what should I do first? Can I just go directly to the court? So I have to read the regulation about civil servant law, and I have to find out the regulation there whether I should do keberatan or not. So sometimes the related laws say you have to do keberatan first, and then if your keberatan is rejected, you have to do the banding administratif. So here you can see the diagram, individual to keberatan. If the keberatan is rejected, so you continue to the administrative appeal, the right side. Okay, the right side. Well, this is my mistake that actually there is one line missing here. Well, actually sometimes the law said you can go directly to banding administratif, but it's missing here. It's my bad, sorry. So the individual can also directly go to the banding administratif without following keberatan. So it depends on what the regulation said. Sometimes the regulations say you have to do keberatan first and then banding administratif, but sometimes the related regulations say, you don't have to do keberatan, but you can directly go to banding administratif. So you don't submit a complaint to the institution or the officer who issued the decree, but you can go directly submit your objection to the higher decree of the institution that issued the decree. So that is the situation here. However, if the related regulation doesn't mandate you to do the administrative effort to settle the case, so then you can go directly to PTUN. You can take a look at the left side here. So the individual, follow the left lines. The individual go directly to PTUN. PTUN here is administrative court. So here, if the regulation doesn't say you have to do administrative effort, you can submit your lawsuit to the administrative court. But if the related regulations say you have to do the administrative effort, you have to follow it first. So let's see what the regulations say. If you have to do keberatan, so you do keberatan first. If after you submit your objection, the institution or the officer accepts, so the problem solved. But if they reject, so you see again what the regulations said. If the regulations said you have to follow the banding administration, so you follow it, and if it's then accepted, the case settled. But if no, then you can continue it. So back to the situation in keberatan. If your keberatan is rejected, so you have to read again what the regulations say, the related regulations say. If the related regulations say you don't have to follow administrative appeal, then you can go to PTUN or administrative court. So here there are several options. It depends on what the regulation said. So sometimes you have to do keberatan first, and then if the keberatan is rejected, you have two options. You can continue with administrative appeal or submit a lawsuit to administrative court. It depends on the law, the related law, what the related law said. Or if the related law never give you a chance to do the administrative effort, so you can directly submit the lawsuit to PTUN. So based on administrative law, if your case has been at the administrative appeal, so let's say that I submit an administrative appeal to the Ministry of the Higher Education because I disagree, I object the decision of my rector when he fired me, for example. Yeah. So if the minister also reject my administrative appeal, so I can go to the administrative court. But according to Article 51, verse 3, when my case already in administrative appeal procedure, so when it's rejected, then I want to bring it to the court. I don't go to the administrative court. I don't go to PTUN, but I go to the higher court of higher administrative court or Pengadilan Tinggi Tata Usaha Negara atau Pengadilan Tinggi TUN. And also if my case has arrived at PTUN and then the judge in PTUN reject my lawsuit, and then I can continue the case with an appeal to Pengadilan Tinggi TUN. So if the case already in Pengadilan TUN and I still lose the case, then I can submit my cassation to the Supreme Court. So the conclusion, the legal procedure in settling the administrative case is based on the administrative court system. And to understand this system, first, of course, you need to read the administrative law, but also you have to read the related law, because administration issue is a broad concept. Administration is exists in education, in trading, and in many aspects of governance, in regional governance, in religion, that governed by Departemen Agama, for example. There are so many administration conduction in Indonesia, so you have to read the related regulation. Take a look at what the related regulation said. If they said you have to follow the administrative award procedure, you follow it first. But if the law never give you a chance for that, so you can proceed directly to the court. And if your administrative award has been in administrative appeal atau banding administratif, then when you want to submit the lawsuit, you don't go to PT UN, but you go to Pengadilan Tinggi Tun. So that would be the closing for this topic. I hope you understand the materials well. Thank you. Ciao.